countries, there are different types of legal system. Some countries practice a combination of two or more legal systems, which is known as mixed legal system, while some countries practice only one type of legal system. But in Malaysia, we use mixed legal system, which consists of the customary law, Islamic law, and common law. The source of Malaysian legal system law are from two different laws, which are the written and unwritten law. In Malaysian legal system, the most important source of law is written law, which is comprised of the federal constitution, state constitution, legislation, and subsidiary legislation. Written law consists of English law, Islamic law, which is applicable to Muslim only, judicial decision, and custom. Part of the law of Malaysia is formed by the English law, which it can be found in rules of equity and English common law.
Establish the framework for the government and outline the division of power between the federal and state government. The federal constitution is divided into 15 parts, each covering different aspects of governance and right. Some of these parts include the structure of the federal and state government, the judicial system, and the right and responsibility of citizens, where laws in Malaysia are made by the Parliament and State Legislative Assembly. Parliament consists of two houses, which are House of Representative, Dewan Rakyat, and the Senate, Dewan Negara. A proposed law or bill must be approved by both houses and receive the royal assent from the Yang di-Pertuan Agong to become law. Yes, that is all correct. And do you also acknowledge that federal constitution and legislation also protect right of the citizens? There is a section called Fundamental Liberties, which guarantees various rights and freedom, such as the right to life and personal liberty, freedom of speech, assembly and association, and freedom of religion. These rights are protected by the judiciary, which can hear cases and provide remedies if they are violated.
Hey, I want to know about case law and Islamic law. Can you explain to me about that?
Of course, sure. Case law is created and developed by judge through decision in individual court case. Meanwhile, Islamic law is a legal system derived from the religious precepts of Islam, particularly the Quran and the Hadith. Islamic law. A big fun fact about Islamic law, which is in 1887, Islamic law has been in Kuala Lumpur, Terengganu, with an inscription which detailed a code of Islamic law. In order, the stone was detailed in year 1303, 100 year earlier than first introduced of the Malacca law.
Well, interesting fun fact. Now I have know about case law and Islamic law, so may I have know more about the law?
Glad to hear that. Okay, now I will explain about the function of Islamic law first. The role of the council is to advise the ruler or king in non-ruler governments on Muslim and Islamic issues. All of these councils are formed by state legislation. The federal constitution also grants and states legislature the authority to enact law pertaining to, among other things, personal and family law for Muslim wakaf, zakat, fitrah, baitumal, mosque, the creation and punishment of offense committed by Muslim against Islamic precepts, Muslim court, the control and propagation of doctrines and belief among Muslims, and the determination of Muslim law. Next, I will explain about the importance of case law. The importance of case law is the law can help legal practitioner understand who the law is read and apply in real world situation. and can maintain consistency in court decision by using legal precedents from previous examples.
Thanks for your info. Now I know more about law because of your info.
So, can you explain to me regarding customary law and English common law?
Of course, customary law is a set of laws based on the traditions, customs, or norms of a local community. It is applied in many countries around the world, often in conjunction with civil, common, and religious legal system. While English common law is a body of law that is created by the written decision of judge instead of by a strict legal code. Customary law is often, but not always, unwritten. It is based on long-standing tradition, customs, and rules that a community accepts as binding. Customary law is often administered at the local level in accordance with tradition and dispute resolution mechanism. However, in some countries, it is enforced within the modern court system. Some national court systems require that customary law principles be proven as a question of fact, whereas others permit proof through written document or prior legal decision. In 1963, which when Malaysia was formed, there were 3 separate statutes authorizing the application of English law, which are the Civil Law Ordinance 1956, CLO 1956 in Peninsular Malaysia, the Application of Laws Ordinance 1951 in Sabah, as well as the Application of Law Ordinance 1949 in Sarawak. Common law and rules of equity, as well as in Sabah and Sarawak, English statutes of general application apply under Section 3, 1 subject to the following qualification, which are the absence of local legislation, cut-off dates, and local circumstance.
Thank you for the explanation. Now I understand a little bit about customary law and English common law.
You're welcome. I'm glad you understand. If you have any more questions, please ask me. Have a nice day. Bye.